Hey folks, we'll get started in about 30 seconds. Who wants? Hey Chris.
Hey. How are you, Santa?
Oh.
I really appreciated the Shakespeare hat and the story. That was good. Because I have to admit, I was kind of disappointed when you just came out in a suit. And I was like, what has happened to John? There's
Why is it John and Sparkles?
Right.
The beard.
Actually, the thing,
That's
yeah,
true.
the thing to do would have been to come out in drag. I'd say, bring the children. I'm ready to teach them.
Okay, so for those of you who are experiencing a little bit of a headache from the previous sessions, I want to invite you back to maybe the 20th century, arguably the 19th. And there's some advantages and disadvantages of moving backwards in time. The advantages, we've got better language to discuss issues, and the implications of those issues are more generally shared by the group than the disadvantage is that you would think, having had several centuries of legal education, this is a problem we would have solved. And the fact that we haven't and that we have to talk about it today is some indication of perhaps the improving interface of technology and legal education. That's at least the message we're going to try to convey here. But at least the need for interaction between those two forces. So, John, tell us what we're going to do.
All right. First of all, this is Marjorie McDiarmid, professor of law at West Virginia
West by
Dan.
God.
By
Is the appropriate first.
West by God University of Virginia College of Law, and I'm John Mayer, the executive director of CALI, the Center for Computer Assisted Legal Instruction. And before I even get to the agenda, I'm going to sound an optimistic note for an hour or less than it takes for this session. I'm going to be wildly optimistic about this moment in time. This is an opportunity. The iron is hot. We can strike it. We can do something that's never been done in the history of legal education because of some of the things we're going to bring up. So we're going to talk about what the NextGen Bar, is going to sort of look like. Marjorie has vast experience on this history, and we'll cover that a little bit on CALI and others who have tried to do or who have done simulation. And when I say simulations, I don't mean paper simulations. I mean computer-assisted simulation of some kind or form. And then I ask the question, can we build simulations that teach law, teach practice, and prepare people for the NextGen Bar? And we break that down into sort of three broadish areas: a very short technical discussion, an essential problem of whether you're going to build an open system or a deterministic system, a scripted system, and then what AI might contribute to all that. And then finish up with another. There's like hillocks and hedgerows of problems here, of whether or not you can build a system that students can use. Well, can you build a system that faculty can use, because it's key to have them engaged in this go round. And so that's a bit of a long trip, but it'll go fast. Trust me on that. So Marjorie,
Okay, so what's the problem? I'm suggesting that we have to go back and solve the problem. What's the problem? The problem is that legal education, perhaps because of Christopher Columbus Langdell, perhaps because of other forces that were operating at the same time, got its start with the notion that what lawyers fundamentally did was read precedent, analyze precedent, deliver precedent in written form. maybe a little appellate advocacy. That's what Langdell did. So maybe that sneaks in there a little bit. But the whole notion of where do you get the facts upon which all this legal advocacy is built, it's totally washed out in that model. The facts in appellate cases are right there, nicely written up for you by the judges, right? And they somehow just ex machina appear. But the fact of the matter is that in real lawyering, you have to talk to clients. You have to counsel clients about their best course of action. You need to negotiate with other people because even back in the 19th century, lots of cases settled, and the numbers of cases that have settled have increasingly grown over the time that they were involved with, and none of those skills inherently are taught or tested by your conventional law school classroom. Actually, back further than McCrae, the legal profession recognized this problem. And considerably further back from McCrae, but at least McCrae embodied the conclusion that in addition to problem-solving legal analysis and legal research, fundamental lawyering skills involved factual investigation, communication, client counseling, negotiation, litigation, problem dispute resolution as the NextGen Bar has it, etc.
Marjorie, for the kids in the room,
Right.
McCrae was, I'll start, and you
Right.
correct me, was a 1990s, early 1990s attempt by the American Bar Association to look at the problems that legal education was having. Put forth by the firms that were saying we can no longer train your inexperienced students in the way that we have in the past. And so McCrae was made up of a group of practitioners as well as academics and yourself. And
I was one of the reporters, not a task force member.
one of the reporters, got it. And came up with this list, this high-level list of things that lawyers do that it would be nice if they came out of law school with some.
Right, with some
idea.
competence to actually perform.
Yeah. So it's called the McCrae report, which a lot of us old people know about because we've been around a long time and we read it. And maybe me, I read it 20 years ago. But it's often just shortened to McCrae. So, go ahead.
So at any rate, now, and arguably somewhat before, the bar examiners have started to grapple with the problem of how do we, if these are fundamental skills that we want people to have, and if we believe it's absolutely necessary to be a competent lawyer, that you have these fundamental skills, how do we test that? How do we determine whether somebody can, in fact, operate in this space in an appropriate manner? And they came to grips with that issue about 10 years ago when they ended up formulating the portion of the bar that's the, I forget what
MPT.
MPT.
The performance.
Performance test, right? And at that point, they concluded that they couldn't do it live, number of technical reasons. It wouldn't be replicable. One person's live experience with one mock client would be different from another person's experience with another mock client, and so you'd get unfairness built into the system, and it was too costly. And at that point, they also, and it really wasn't seriously on the horizon, concluded the technology wasn't good enough to do this in any kind of generally available format. So that's when the performance test was developed. The next slot cut at it is the NextGen Bar description. And if you start reading the documents for the NextGen Bar early on, they're identifying all of these skills, and they're saying we're going to try to test them all. But as that document is developed,
Big butt.
they have stumbled again on the technical issue and have come to the conclusion, probably without working very hard at it, that
No.
we're among friends here, that it's not technologically possible to make the kind of testing involved work. And as a result, they've fallen back on something that's really sort of a gussied up version of the performance test. Perhaps expanded a little bit to include notions of how would you, the performance test says write a letter to a client. Now they're saying, what would you identify to a client as the pros and cons of their position? The performance test says that you should think about various issues in drafting a contract, but they're now proposing that you try to formulate a negotiating position. But all of this is written documents that frankly, except for the advice letter, most lawyers don't write. You don't write out your schema for a negotiation. You identify perhaps your position points, but you don't have any, you don't try to script a negotiation because you can't, right? And so asking folks as a test to do a task that they're not in fact going to do is somewhat counterproductive. Okay. So the first question becomes, if you're actually going to try to test something like lawyer-client counseling or negotiation, is there a shared body of standards against which you can test? And there's some concern, I think, on the part of the NextGen Bar about that. My response is there's a whole lot of material that we've developed in the last 15 years on what's good lawyering practice and what's not good lawyering practice, on what works in negotiation settings and what works in client conferencing. A lot of it's drawn from other disciplines. It's drawn from the economics folks and the business folks. It's drawn from the psychologists. It's not, in my view, unfortunately, much drawn from actually empirical work with lawyering. But it exists out there, and it's a pretty shared set of standards. So I think we get past that problem relatively easily. And that brings us to the next problem, which is, can we construct viable simulations that can then be the basis for questions to students about various lawyer performance activities? And there's a history, so John, let me
Oh,
talk about
history. Yeah, we've got to do a little throat clearing history, but it's not just to honor it, it's to look at where our history informs what we're going to be doing, what we think we can do in the future. And there are some very informative things. So it goes back to the 80s. This is a lesson, I don't know, it was written originally, what I love is about many CALI lessons has got the copyright from the beginning. So written originally in '83, it's now been, whoopsie daisy, it's now been updated even into the new versions of CALI author, so it's got 2019 sort of stuff. But there it is, a DOS, something that ran on an original IBM PC that would, in text, would ask you questions, or you would read a transcript of a direct or a cross-examination, and then it would, pause and ask you questions like, should you object at this point? Yes, no. What would be your objection? Well, it might be, you get a multiple choice, and then it would give you feedback, and it would loop or branch based on that. That's a simulation. Now, it's a simulation of a very narrow, special situation, a direct examination in a court case or something like that. But at least it gives you some idea that even back in '83, you could sort of do this with just computers, right? And that's where CALI got started in 1982, computer-assisted legal instruction. So back in our history, but very vital. So less than a decade later, they actually built the interactive video systems, and I did everything I could. I tried several different ways to get a video to show you, and I have actually a USB of the working system in here, but it only runs in like the original version of Windows 95, which I did install on a computer and try to get it to run, and it kept on bugging me about device drivers and stuff. I tried doing it 4 different ways. Anyhow, long story short, the interactive video discs. Actually, let's ask, how many people have not seen what I'm talking about, the interactive video discs? How many people am I going to have to describe this to? 2 or 3? All right, but the rest of you have seen it, so bear with me for these folks. I'll be fast. So it basically was a laser disc player that was plugged into a TV, and then both of them were plugged into, or the laser disc player was plugged into a PC via a serial port. So the PC, so the thing would start, and by the way, I have a lot of personal experience with this, because when I was the IT director at Chicago Kent, it was my job to nurse this recalcitrant baby and keep it running while droves of students, they would always be in pairs or in threes, would have to sit down and spend 2 hours with it, and something would inevitably go wrong, and I had to learn how to keep it going. Anyhow, so on the TV would play, again, a court scene. A prosecutor interviewing a witness, and at various points, the students had to hit the space bar, when they ask a question. And then on TV, the judge would pop up and say, what's the basis for your objection? So the space bar was the object button, right? And then on the PC would come up with a multiple choice question. It would say, argumentative, relevant, foundation, hearsay, a whole bunch of things. And then you would have to pick it. And sometimes when you picked it, the judge would say, I need more information, and then another multiple choice question would come up. Sometimes the judge would say, sustained, and it would be like, yes, you got it right. And sometimes the judge would say, no, that's not, impermissible hearsay, can you tell me why? And then you would have to answer a question on the PC, and sometimes they would say, nah, overruled. So, there was a lot going on, but it was 3 devices running this sort of thing. And if you just let the video play all the way to the end, then all the testimony got in, and you'd get like a very low score, and the judge would be, you're a crappy lawyer, essentially. So you were essentially trying to barricade, stop, you're trying to stop. Now, you could overdo it too. If you objected too much, eventually the judge would pop up and say, would you shut up, or something like that. And the actors they got, had lots of reality and verisimilitude to it. So it was really good. The video jumped on the student's response, and if they objected. So faculty loved this. It wasn't. I'm not even sure it wasn't entirely a CALI project. It was a Harvard-Stanford project or something like that. But the technology was not gonna survive very long. All right. So so later iterations of this same idea played out through the 90s. This is one of them. Let's see if I can get it to run. Which Marjorie was able to get to run. So we did some video just to show you sort of what it looks like.
awards, if any, have you won?
Objection, Your Honor.
I'll read this. This information is relevant to the witness credibility, especially because he will be testifying about the music business and, more information about why the objection was overruled. And then the federal rules of evidence. Okay. Is there any basis on which you would sustain? So, no. That's correct. So imagine that playing out for like an hour or so. I mean, to get through the whole thing. And it would pop up with FRE, which rules, so the student could click on that and view the federal rules of evidence. Kind of fun, kind of slick. Oops, there we go. There were other examples of that, even some commercial ones. There's a game called Objection, which didn't use video, it used more animation. Sort of looked, Super Mario Courtroom. Or
And
something
that
like
one
that.
still exists, you can get that.
Yeah, I think you still can. It's like $69 or something like that. Learning evidence, I never saw this one from West.
This is the stuff that's in the electronic materials for my current evidence casebook. And it is static shots, actually hand-drawn of witnesses and lawyers, voiceover, but same idea. Object when you believe the lawyer has asked an improper question, give me the basis for your objection.
Yeah. And there was an attempt to make video discs that did more than just evidence stuff. Negotiation, client counseling, negotiation. And they didn't have the same interactivity because it wasn't the same sort of, it could play and you could stop it and you could get points. I don't think they were as popular.
Well, I mean, part of the problem is the advantage of evidence from this point of view is that there really are answers.
Yeah.
And if you don't, and this goes back to our agreed set of standards, if you don't have answers, it's hard to program a yes, no kind of thing.
Now, in the 90s, Paul Mahar, who's a law professor from, he's from Glasgow, built a fictional town called Ardculloch, in which it was basically a collection of websites, or a website in which you could click on the various parts of the town, like the police station and the morgue and the bakery, and get information about it. And then you, as the student, had legal matters. The baker is suing the city because the potholes haven't been fixed in front of it. And then the way the student communicated that is they would email people at the police station or at the court, and TAs would pretend to be those people and answer those emails. So it's sort of like a Potemkin town with fake TAs behind it, but they were not AIs or anything like that. They were human beings. So it cost a lot, or it was difficult to do, but it kind of worked. I don't know, kind of worked. We had a small project at CALI to try to take it and then run it and then maybe automate some of those back-end pieces. And there was just too much to do with the technology that we had at the time. He comes up later again. And there are some games out there that sort of cover some of this same territory a little bit. First Degree, how many people have you heard of that? No? I don't even know if you can buy it anymore. It used to be a
You
CD
can run it off of YouTube.
Oh, you can run it off of YouTube. Yeah. See, that's the technology's changed since then. It could be done, right?
Yeah, and the advantage here, this is an interview. This is not a piece of litigation. This is an interview. You're conducting an interview with this witness. You do it through selection from a list of multiple choice questions. So you're not having live interaction with the witness that you would have in real life. But how you choose to ask the question branches into you get information, or the witness clams up on you, or the witness gets angry and walks out of the room. So there's a feedback loop in terms of, are you doing a good job of identifying the kind of questions that you ought to be asking a client or a witness in real life.
Right, and this is an opportunity to use the word gamification. Say, this is
Which
sort
is
of
one of John's favorite words.
one of my favorite words. One of my favorite words. Not because you can get the high score or something like that, but because gamification can be used as a motivator to keep the students engaged and interested. All right, so can we build sims that teach law, practice, and prepare students for the NextGen Bar, theoretically for these MPT 2.0s or these advanced or these gussied up MPTs, which we don't know exactly what they look like at this
Or
point.
more realistic entities.
Yeah, or even something better. Maybe we could go do better than what they had hoped to do for that sort of thing. So first, let me talk about some sort of broad technical issues. First of all, the basic idea behind a simulator, the best one is, a simulator is going to show you a problem, and then it's going to solve it for you in front of you, right? You're going to see how it's done right once. The second level is the simulator gives you another one and says, you go ahead and solve it. And then it tells you whether you did a good job, or what you missed, or how you could have done it better. Sort of a diff, Here's the ideal, here's the rubric, here's the model answer, here's how you diverged from that. All right? And the last one is the most powerful in ed tech or in educational instructional design, is when you build your own simulations. And then something else tells you whether that was a good, a realistic simulation. In these cases, it's hard to have the computer evaluate what you do, so you might use instead the instructor grading you or peer assessment. In other words, students seeing how other students build these things could inform them on like, oh, I hadn't thought of it that way. I am not a PhD in educational technology or instructional design, but I read a lot. And that is always held out as the let students build their own instruction. It's sort of constructivism. It's a powerful model. So, and this is a gross simplification, but I'm trying to make a point here. The thing you saw was, opposing counsel is doing direct exam, the player objects by pressing the space bar, there's a branch, if the judge asks why, you pick the right answer, you pick the wrong answer, you get either the judge, dinging you or praising you or something like that. I wanted you to do this to point out that a key element of all of this technology is branching. In other words, there's consequences to your interactions with the system, right? And that branching has to be not simple yes or no. It's not just choose your own adventure. It might be based on where are you in the simulation, what have you done previously. In other words, if you screwed up multiple times, then maybe it's gonna kick you out faster than if this was your first screw up or something like that. So the system has to have a state or a memory of the gameplay that's going on. All right? Sorry, simulation play. Game just slipped out there. All right. So this is really, if you think about it, it's a script, right? We need a script, and we need the script to be turned into audio, and we need the script to be turned into, in the case of the interactive video, into video. If it's a game engine, then we need it to be turned into video, which is characters on the screen. But I'm gonna not go the game engine route yet. Or at all maybe for this talk, and just talk about, look, we need audio and video. And it used to be really expensive and hard to do that. And that's why those video disc projects in the 80s were a little amazing, but they spend a lot of money hiring actors and renting cameras and lighting and makeup and the whole thing. I don't even know how much they spent on those, but for the time, probably way more than like CALI's yearly budget. All right? And that's not true anymore. That's cheap now. I can get a script of text, and I can feed it to Poly, and I can have 47 different voices to choose from, including the ability to put SSML, speech synthesis markup, that basically is make the voice sound angry, make the voice whisper, make the voice, sound tired, and all sorts of things. And I can do it for dollars per page of text, not even. The point being, that's ridiculously cheap compared to what it used to be. It's better or worse than that. There's a tool out there called Synthesia, which works almost the same way, except you can do the same thing. You can feed it text, and it will give you a talking head that looks 98% realistic. It's got a little uncanny valley going on it. Now, Synthesia is mostly trying to sell this as a marketing tool for people who are doing marketing commercials or things like that. They're not. I talked to them a few months ago. They have no idea what of the power of this in an educational market, except in sort of the corporate training market, which is this gigantic billion-dollar market. They're somewhat unrealistic for what we want to do because as I'll explain later, they want to basically make money every time you API their system. So they're sort of like ChatGPT. They're not as expensive as that, but it's the same sort of pricing model that makes them hard to deal with. But even so, super cheap compared to renting cameras and hiring actors. So boom, right there, technology replacing human beings. Right? I don't need actors. I can fake them. I can deep fake them. So that's what's different now, technical wise. If I can get a script, I can reproduce what those interactive video discs did today, like nothing, right? But of course, I want to go way beyond that, all right? So to go way beyond it, I have to first start thinking about open versus deterministic. Those interactive video disc lessons were highly deterministic. You could probably watch them once or twice, and you could almost draw the decision tree from that. What causes the branches to happen, things like that. All right. So that's a key factor in design of any authoring system that we're going to do here. And I'm at the point where I don't know the answer yet because I much prefer deterministic systems just because I can control what's going to happen, and I think they're easier for faculty to understand.
They're also, I think, key to a use on a bar exam.
Because of their
You cannot
reproducibility.
have different takers of the bar coming up with wildly different responses, all of which might be right given the vagaries of the system.
Yep. So there's so many advantages to the deterministic, but it's a lot of work to make something of sufficient complexity deterministic. It's not just a couple of branches, it's dozens, it's hundreds, maybe, it's hundreds of branches. And it's tedious to test all those because it becomes a combinatorial problem of making sure all those are done, unless you build an automated testing system, which is interesting to think about. So the medical folks have solved this problem by spending the money on training actors to become simulated patients. So they train people and tell them what their disease or malady is, and then they walk their doctors through having to interview them and find out what their problem is. They spend a lot of money on it, but they get good results, and they use these as what's the word? Gatekeeping tests.
Mm-hmm.
Right? You have to pass. Part of your boards includes live simulated patient diagnosis. Why don't we do that? Well, because
they have lots more money.
lots more money. Right. And what do we mean when we say that? We say 40,000 people taking the bar exam. Each one has to talk to at least one or two or three simulated clients. That could get rather expensive. Right? It wouldn't cost $100 to take the bar, it would cost $5,000 or something like that. All right? But there is a simulated client initiative, and the name behind this is Paul Maharg. Sounds familiar, right? Mr. Kulik from before. I love Paul. He's a great guy. He was even a keynote speaker at one of our conferences. I don't know how alive this is, but I do know that they've done, and of course it's the Canadians, they're way ahead of us. It's they trained people to have particular legal problems and had students as a test or as a study to have to interview them and get the information that would allow them to proceed with that sort of thing. So anyhow, it's good to know that that's out there and that it's been solved in a different way, but it doesn't solve our problem of how do we do this inexpensively, And I thought, not everything has to be totally deterministic. Maybe it's more like occasionally deterministic, but every once in a while it's stochastically open. So you get into like a certain area, like where you're in a certain mode of questioning, and it's wide open until you sort of, you've satisfied or you've exhausted the client, and then you move on to more deterministic things. So it's still a decision tree, but it has these blobs of open conversation in it. Why would you want to do that? Better verisimilitude, again, more realistic. All right. So here's the challenge. You've got your bright young law professor who knows all about how to teach legal skills, and you want a script out of them, and you want to do it without killing them. How do we get that thing out of their head and into that script format, right? So maybe AI can help us with some of that, or maybe AI can help these professors do some of that. What you just heard about a little bit from Elmer and from previous sessions today is that there are open source models now, including ones that are where you can create your own custom AI chatbot. Now, I don't want to create a chatbot. I want the AI to generate the first draft of the script to get to get the script flowing, so to speak. And that is like just barely within our reach about now. Like, we could probably train a chatbot, a large language model, to generate scripts around certain legal topics. My guess is it would need an extensive amount of editing and refinement, but we'll learn and get better at it. Maybe. I mean, that's the open-ended part of this talk is I don't know whether or not we can actually build an AI assistant author sort of a thing, and whether it could be made smart enough to come up with realistic or useful simulations. I mean, how many different types of, there's got to be a category of things to simulate.
There are lots of existing simulations. They're used by clinics live with classes to demonstrate interviewing or negotiation or client counseling. All of those things exist. They exist in every law school in this country.
Are they sort of like
But the
HBR?
trouble is they're just a couple pages worth of information that the human being channels into believable speech. So it's that step. It's not thinking of the problems. The problems exist.
That step.
It's the step of turning it into the branching. That is the problematic piece.
I don't know if this is the right question to answer. Are those copyrighted? Are those shareable? Are those easily, do you think in the right situation people would make those available?
I am sure in the right situation people would make them available. They're copyrighted and they're individual work product, but.
Because the individual faculty have built them for teaching their courses.
Right.
Got it.
But some of them are published in books, but a lot of them are just free form sitting out there.
Got it. All right. So I found an article because I was looking into this for this session, and this article passed my path just 2 days ago. And this is a whole fortune article about a guy who likes to be a dungeon master. I don't know if any of you know much about D&D, but part of the tediousness of being a dungeon master is writing up the backstory or some of the histories of the places that your dungeon team will visit and something like that. And so the suggestion of this article is that, we can use ChatGPT for the parts you do not enjoy. It's easy to imagine offloading some of the work I don't like onto an AI with correct prompts. With ChatGPT, in a matter of seconds, I was able to enter a list of bullet points for a setting I had in mind and have a 500-word description generated to read to my players. So that's fascinating because creating a simulation and being a dungeon master are, this is where I went, whoa, that's kind of similar. Maybe there's some insights to be had from looking at D&D culture. What do you think, David?
I've done that.
Yeah, so have I.
Well, what do you think about my comment about D&D and teaching?
I think there's actually a lot that you could be getting by looking at the role-playing game cultures, and not just D&D, the ones that are more based around personal interaction, because D&D is very much simulationist in terms of what you're trying to accomplish, but I'm in a lot of communities that do very personal interaction-based games, and there's a lot you could do with that, like generating that, so.
I wholeheartedly agree. I had been thinking before you got to this, I was like, this is very much like some D&D related stuff, and I've been doing stuff with it in my classes where like we do a simulation where I have, when we do, we'll introduce some new piece of technology or something, and then because students, it's hard for them to talk because sometimes they're worried about saying the wrong thing. I'll have them play roles, and we do like a D&D alignment. So like you're the senior partner who hates technology and has this, and that gives them a role that they can inhabit, which then allows them to interact. So there's so much to be mined here.
Yep.
And then also at the danger of like, you really got to come in and talk to me, because my entire thing is about a structure that we put together for generative outlines to create novel documents based upon interactions with LLM, which is, we're going to talk later.
All right. Yeah, I remember a few years ago looking at dungeon generating tools as a way to generate art collects. You type in what you want, it creates a bunch of like names of companies, it generates the websites with the proprietors' names and addresses, and then boom, I've got an art collect maker. Now I just got to staff it up with TAs and things like that. So I'm not surprised. So cool. All right. So this leads us. We're finally getting down to the nitty gritty. Can we create a user interface? Because I think we can create something that students can play, but I don't know if we can create something that faculty can build. And I know that's like it's another burden. I can write a CALI lesson, but can I write a CALI author? It's a bigger burden, but but I think for success it's important. And here's why. Right, so here I had my script, that can generate my video and my audio, but writing that script is really hard, getting that out of the heads of the instructor. But what I really want is to be able to iterate on this. I want the instructor to be able to go in there and say, I'm going to build a little simulation, and then I want him to hit play and see how it plays, and then I want him to go back and say, no, I want, it's a little bit better, a little different, and then play. And I want the faculty member engaged in the construction process, partly because the real heuristic knowledge is in their head, that little sunspot on their forehead, and partly because I don't want them offloading it to the tech people. Hey, can you build this for me? And we've run into that with A to J Author, where the entire goal was the SME, the subject matter expert, would be the one doing no coding. And the problem is they basically type up the questions and branches and then hand it to a coder for our no-code system. So there's somewhat of a failure in being able to create that interface. All right. So we have this tool called CALI Author, which does about 70% of what we want. Right? It's a no-code tool. It creates XML. We can train non-tech law faculty in a couple of hours. It's already got, made AWCAG. It works on mobile, and we've got this whole ecosystem, 1,200, 1,400 lessons running. right? It already does branching, although right now it only does simple branching, but we could probably add that capability in, which is important, right? And it does analytics. So that's kind of nice. So if we got a simulation and there are points where some information can be pulled out that tells the instructor or the student about how well they're doing, we can capture it, right? We've already got that built into CALI Author. We've got a model for how we build CALI lessons called our fellowship model. We bring together 5 faculty, we make them write a lesson, we round robin them to look at each other's lessons, and so every lesson is as good as 5 people can make it, not just as good as 1 person can make it. We get 5 experts, 5 subject matter experts working on it at the same time. They also challenge and compete with each other a little bit. And by the way, we pay them to do this. We have to pay them, otherwise they get busy with something else. So the fellowship model has worked really well for us. We've produced 500 CALI lessons that way, and the quality is often very high, all right? So about this time, I also ran across, I mean, I swear, the articles just come like at the time. George Siemens, who's a guy I really like reading about. He's another, I think he's another Canadian. He's got his own AI newsletter. But I want to read this to you because I think it's why we should do this. Textbook publishers and educational content providers have a short life ahead unless they dramatically change their value points. Tools that capture process and engagement will provide critical value. The future of AI tech in education will be an intersection of learning content where even education personal AI tutors will increasingly be in competition with ChatGPT, and learning processes where engagement in community will be key. He's basically saying the commercial publishers are in trouble. And I agree with that. I know I'm eating their lunch with my open casebooks right now. And I think they're not smart enough to think through this building model either. It might be too expensive for something for them to build. I don't know. So too long, didn't read. Law faculty who graduated law school before 2025 will have a lived experience of law school and the bar exam that is radically different than the students who are going to start taking the exam in 2026. There's going to be a cognitive dissonance between faculty now and students later. What do you, I mean, that's got to be a huge concern, right?
Yeah, to the extent that it's real, yes, it's going to have concern. Fundamentally, the tasks, regardless of the lived experience, fundamentally the tasks remain the same. Human beings are human beings. They react with each other in fairly predictable ways. We're trying to teach people how to maximize their client value through an understanding of how to perform those functions.
Mm-hmm. So I think it's going to be really hard to get faculty to be told to teach different, without them having the opportunity to
I've just illustrated for you why it's difficult, because that's how I conceive the world, and that's how my colleagues conceive the world.
Yep. Without having the faculty actually practice at building the tools that teach law practice and theoretically prepare them for the bar. And that's the goal. I mean, this is my optimistic goal. I want to build a no-code, iterative simulation authoring environment. And I think I'm close, even with the limited resources, and programmers that I have. So, this is our last slide. We're in a maelstrom of change right now, right? Access to justice crisis, the NextGen Bar, the ABA, highlighting law practice. Education can no longer be about memorization and regurgitation, because you can just ChatGPT the answer. You can have it write the essays. And so this is an inflection point. This is a perfect storm. I hate that analogy, but I use it so much. And therefore, it's an opportunity. It's an opportunity because we're not driven by the need to figure out how to do all this and make the maximum amount of money. which the commercial publishers might be, or businesses might be. You know, we have a mission that we want to solve, and maybe we can solve all the problems all at once with what I'm talking about.
So the value here, in my view, is not simply to convince the state bar examiners that they can do this and that they're being too chicken. The value is to use these kind of simulations to actually reinforce teaching. One of the problems that we have in all law school skills teaching is getting people enough iterations of the issue to take the knowledge out of the theoretical and make it ingrained. We can only run so many mock trials. We can only run so many appellate arguments. We can only do so many client interviews in ADR or in clinic, et cetera, et cetera, et cetera. If we can figure out a way to automate this process so that people can have an iterative experience of learning how to do these skills, we will markedly improve the performance of our students and therefore markedly, we hope, improve the quality of lawyering that the citizens of the US get, which right now is pretty not good. And it lies within our power to harness some of these new tools that we're learning about and some of the old tools that we illustrated for you that already exist to provide that opportunity and provide that improved lawyering competence. So that's.
So, reactions? You're crazy? Sounds awesome. Questions? Steve?
Yeah, I'm struggling because let's say client counseling.
Yeah.
Let's do it, client counseling simulation.
Right.
So obviously, part of what you want to be assessing in this simulation is the student getting the information from the client that they need to?
Right, that's part of it.
But also, how are they going about doing that?
Right. Yeah, and there are models of counseling that largely come out of the business school milieu that talk about how you do that.
Right.
And give you sort of a cookbook version of how to make that happen.
So what I'm struggling with is how to automate that so that it is more open-ended as opposed to the here choose question A versus question B. It seems that for summarizing the client information, maybe, and I'm not positive that I believe this yet, but maybe the AI can do somewhat of a decent job on answering your questions, knowing what the client has, so maybe you can be more open-ended in asking the questions to the client because of the AI. But do you then also, what do you use then to build in a way to assess how the student is choosing what questions to ask the client to determine whether they're asking the right questions with the right tone, in the right order, etc.?
What I'm suggesting to you is that we know a fair amount about how to do that. It has to do with issues of getting the client to articulate first before you put a limiting scope on the options that are available. Getting the client to articulate from their point of view what the pros and cons of each option are, Because clients frequently value things differently from the way lawyers think they ought to value things, right? It may sound to you like your client is always gonna want the most money, but that's not true. If there are situations in which relationships are gonna be irreparably damaged that the client cares about, they will give up money for that. That's information that we know how to evaluate.
Are there ways to use AI, though, to identify whether that's the type of question that a student is asking, or
I'm not sure that, I think a little bit behind John here is, I'd be happy with a good multiple choice system.
Right, yeah, see, I can,
I would be happy simply to give people enough chances to practice with a good choose the right road system, without putting in AI.
Right, so I'm confident we can build a deterministic system that is better and easier for faculty to build, and so get to where Marjorie wants to be. I'm less confident, but intrigued by the idea of conversational AI research that's going on right now, using things that we've seen only come into being in a fairly recent time. That might be a way to have, the AI be your NPC, the non-playing character that can respond to prompts that you give it in a sophisticated manner, or it's actually not sophisticated, in what looks to be a sophisticated manner.
But, I mean, either one would be a step in the right direction. And
Well, walk before you
as an
run.
incrementalist, I'd be inclined to say, let's play out the multiple choice, essentially the CALI fellowship model.
Well, and that's why I said stochastic open. You have to build a deterministic system, because there are going to be some points in all simulations that are just like, yeah, you just swore at the client, straight to jail or straight out the door. You know what I mean? There's no like, I got to think about this before I give you some bad feedback. And then there's like open. It's like, I don't know. So I think you're right. You walk before you run by building a deterministic system, and then you find places that drop the open into it, where it can benefit and where it will work. That's
Yeah, and I may be being too limited in my imagination about how you could take that next step. But we aren't even to step one, so at least let's get there.
Yeah, when we conceived this session, it was like, yeah, let's talk about the NextGen Bar and stuff. And then it turned into a series of conversations that got us to like, yeah, this is interesting. It's a real opportunistic moment. So 2 minutes left. Comments, questions,
I don't think you're crazy, John.
or should we go drink? Oh, you don't?
I also think there's another layer here, and I think you alluded to it when you talked about peer evaluation. But the wind is north by northwest, so you're fine. I think you could actually use some of the technology tools to help leverage peer evaluation. It's sort of a la crowdsourcing, to do some of that nuanced human checking, so that you don't ever replace everything, but you might make the load enough that it pedagogically becomes part of the training for the students themselves with that evaluation, so that you're getting that for almost for free from the bit, and it's serving a pedagogical purpose. So I think there's a way to. I'm very intrigued by this.
I love the idea of scalable peer assessment. There's a lot of like gears and moving parts in the ones. I don't know how many of you have ever heard of rotisserie, a system built by Harvard for doing large-scale peer assessment. Fortunately, it was written in Java, so the techie side of me comes out. It's like, oh, written in Java. I'm not going to touch that crap. And now there's a whole bunch of rather large companies out there doing peer assessment. So perusal, peer grade, peer IO, all around the same idea of make the students write, make the students evaluate, make the students evaluate the evaluations as a sort of a cross-check. Because there's a who's the Carnegie Mellon guy? Thorne McCarty? No, the other one. Oh, I can't remember his name. Anyhow, he wrote a great paper about, he could train people. You can be trained to do peer assessment almost as good as an expert with just a few iterations. That proves that you can do peer assessment as well as having to hire an expensive person to do the actual assessment. I didn't say that very well. The point being, I'd love to be able to build peer assessment into it, but it does add a level of complexity to the thing. But hey, if you're going to build something impossible, you might as well promise everything. Well, good. All right. It's 5:01.
Sorry, one more thing. So one thing I'm not clear about NextGen, because we've been talking about in Minnesota, is that every state's going to have kind of its own take on what this is going to be. And so that, at the moment, makes it a little fuzzier than just, here's a thing we're going to do for everybody.
Yeah.
Well, I think that's still very much in the development stage. They have come out now with a topic list in substantive law. They're not going anywhere near serious description of the skills piece. But they've come up with a topic list in substantive law that there's certain kinds of things that they're going to test on the assumption that students don't have to look anything up, in other words, walking around legal knowledge. And a certain number of things that they're going to test on the premise that people are allowed to use a limited library to answer, so more reasoning kind of questions rather than memorization kind of questions. That's as far as they've gotten in terms of anything that that's the most recent.
Right.
They say happening in
Minnesota, one of the things
2026.
they were trying to do was try and figure out how to offload to the law schools, to do the portfolios, to do an assessment as part of it, and then even look at the Wisconsin model. So my only concern is that we're still a ways away from knowing what is going to happen,
Yeah.
which could impact what you're thinking.
But
Sure.
all the more reason to try to get in and start influencing
And get ahead.
thinking.
I agree.
All right. Let's go have a beer and watch some magic.